Welcome to everyone, and thank you so much for joining us for this. I'm very excited to hear our presentations. And my name is Deb Dale. I'm the Chief Development Officer for Arizona Public Media. And a few Zoom housekeeping items. I know we're all pretty used to Zoom by now after 15 months, but we've muted everybody as you come on, just to keep anybody from accidentally taking over the screen. And if you do have any questions throughout the presentations, please go ahead and put them into the chat box as you think of them. And then we'll do a Q&A session after both of our presenters are finished. And we're also recording this webinar, as you noticed when you entered. So we will make this available if folks want to share it with other people at a later time. And I would just like to take a moment to say we are always so grateful for your support. So a big thank you to the members in the group and to all of you for listening to and watching our stations. And you probably know this, but we have 3 television stations, PBS 6, PBS Kids, and also PBS Plus. And we actually have 4 radio services now. We have NPR, 24-hour classical, 24-hour jazz, and the BBC World Service on an HD radio channel as well. So as we go through these presentations, please do bear in mind that this information is important for any nonprofit you may want to include in your estate plans, not just for Arizona Public Media. And I would like to give a thank you to our development team at AZPM, and that includes Enrique Aldana, who is our development director, Betsy Leader, who's our Associate Development Director, and Hannah Birch, who is our Development Assistant and also our in-house Maven of Zoom, among many, many other titles. And now I'm thrilled to introduce to you our presenters. We have Jim Krogmeier, who's the Associate Vice President of Gift Planning at the University of Arizona Foundation. Jim joined the U of A Foundation in January of 2017. He obtained his Bachelor of Arts in Economics at Northwestern University and his Juris Doctorate from the University of Iowa College of Law. Jim is also a chartered financial analyst, and prior to joining the University of Arizona Foundation, he worked for Marquette University as Senior Director of Development Plan Giving. He has extensive experience in plan giving, estate and tax planning, and wealth management. He's a native of Iowa, but excited to be with us here in Tucson at the U of A Foundation. And Jim's fun fact is that he is a huge English Premier League football or soccer fan. And next, I'd love to introduce Christina Noz. Christina is an attorney with the Tucson estate planning firm Moeller Conway. Prior to practicing law, she worked for a decade as a fiduciary in an independent trust company. Having administered estates and trusts of all types, Christina understands the importance of drafting an estate plan that clearly reflects clients' wishes and the legacy they want to leave. She is a member of the Arizona and California state bars. She received her undergraduate degree from the University of California, Berkeley, and her law degree from the University of Arizona Rogers College of Law. She proudly serves on the boards of Arizona Public Media. Thank you very much, Christina. Pima Council on Aging, Southern Arizona Estate Planning Council, and the Sunrise Drive Elementary School Family and Faculty Organization. And Christina's fun fact is that she may listen to more NPR than anyone we know. In fact, when quizzing her son on his address and phone number in case he ever got lost, her 5-year-old thought that his telephone number was 621-1600, which is Arizona Public Media's pledge telephone number. So thank you for that, Christina. And with that, I will turn it over to you to start our presentation.
Thanks, Deb. I'm not sure I'm going to win any parenting awards for that, but it is a fun fact. So another fun fact, I'm an attorney because of planned giving and legacy giving. So my first job out of Cal, UC Berkeley, was working for the Lucille Packard Foundation for Children's Health in their fundraising department, specifically in planned giving. And I just loved the collaborative work that we did there to help donors get charitable gifts through their estate to the foundation that I worked for. And it really did inspire me to go to law school after 3.5 years there. So that's kind of another fun fact about me. So today what we're going to be talking about is gifting. And I'd like to start out because we're going to be spending a lot of time talking about you all in the audience, gifting to charity, about a gift that you can give to yourself and to your friends, family, and loved ones. And that's the gift of an estate plan. So if you don't take anything else away from today's talk, I think one of the things that I hope you'll remember is that you should have an estate plan, even a basic one, in place. It's a gift to yourself because even though we're going to be talking about a lot about what happens after your death, we all know that we're living longer, and I think most of us don't like to think about it, but we may experience a period of incapacity before our death, at the end of our lives. And that may be 3 days, 3 weeks, 3 months, 3 years, we don't know. But one thing that an estate plan can do is help you identify the loved ones that are going to take care of you. It could be loved ones, could be an entity, like the trust company that I worked for, to take care of you during a time when you're most vulnerable and in need. And so the documents that you put together in an estate plan, a will, a healthcare power of attorney, and a living will, and a durable power of attorney can help you stay out of court, can help from you having a guardian or a conservator appointed over you, can save you a lot of trouble and money too. Also a great gift to your family. I think it makes it a lot easier for loved ones that you leave behind. I had a couple in the office the other day, and wife was saying how lovely it was that her father had set up an estate plan for her and her siblings when he died, and that even though the work was tedious and it took longer to administer the estate and trust than she thought it would, it was all laid out there for them, and everything went very smoothly. So it's really is a gift, I think, to your loved ones, helps you make your wishes very clear. And then, of course, what we're going to be talking about today, which is legacy giving, making sure that your wishes are carried out. So what is legacy giving? I love this image that you see on your screen right now. I think it's really about your values. And I think we're all here. I know I'm here because my values align so well with Arizona Public Media that I want to make sure that those values are preserved for the future. So what does that mean? That means I give annually, I'm a sustaining member, but also when I get the chance, when my son is old enough that I know he's flown from the coop and off, I'll be including AZPM in my estate plan. And really what it is a legacy gift is a planned gift. So you're planning something. So you're planting a seed, and it's arranged now, the gift, but it doesn't come to fruition until a future date, most of the time. And as a trust officer, Deb mentioned that I spent a decade administering trusts and estates. And in that decade, I was taking people's estate plans and executing them. And a lot of my clients were very charitably minded. And it was so much fun to administer those estates where I got to hand over the checks to the charities. And I was able to see what a game changer a legacy gift is compared to, say, an annual gift. It can be such a significant amount that it really impacts the bottom line of a charity's budget in a given year over a period of years. So oftentimes you can give a much larger gift at death than you can during life. Today we're going to be talking about 3 topics, pretty ambitious. First one is going to be a simple bequest. Second, gifts from retirement plans. And third, gifts via trusts. It's a lot of information. I'm going to try to keep it very high level because I could spend an hour on each one of these topics, but we're going to try to do it in about 15 or 20 minutes. So bequest is the most common and easiest type of these gifts to accomplish. And it can be made either in your last will and testament or in your trust. And we have two ways to structure a gift. As my mom likes to say, money honey. The first way to give is given a fixed or stated sum of money. It's often referred to as a pecuniary bequest. And a very simple example is inserting a statement into your will or trust that says something to the effect of, I gift, bequeath, and devise $10,000 to the University of Arizona Foundation for the benefit of Arizona Public Media. What are the pros of this type of gift? It's pretty simple, right? Pretty easy to understand. One of the cons is that you got to make sure you have enough assets at the end of life and at the end in your estate to make sure that the gift can be made. So if you die with less in your estate than the amount of the gift or things that you're giving away, could lead to some work that has to be, extra work that has to be done. Next way you can give is you can give all or a portion of the remainder of your assets after all the distributions have been made, including debts and taxes. And so you see on the screen here all the different percentages. It's flexible. You can choose any percent that you want. I've had clients, you know, give as little as 0.5%. I'm not saying I recommend that, but you can really customize the percentage that you want to give to charity. So an example of the language that we often include can be something like, I give, devise, and bequeath 10% of the rest, residue, and remainder of my estate to the University of Arizona for the benefit of Arizona Public Media. So the pros, this is pretty apparent, right? You can give an amount that flexes with the value of your assets, right? So if your assets increase, charity is going to get more. If your assets decrease because you're using them towards the end of life for care and such, or just because you want to bounce that last check, your assets, the gift will be smaller. So one of the cons to this that I hear other estate planning attorneys talk about to this approach is that the distributions are made over time generally, because if you have an estate that's being administered, you might have an initial amount that's released from the estate or from the trust, and then over time, you know, various other amounts are released as the personal representative or the trustee works to close out the trust or the estate. So the charity may have to wait for a gift. So those are the two ways. You can give a dollar amount, you can give a percentage. I wanted to talk just briefly about restricting gifts. In my days as a trust officer and now in my days as a practicing attorney, I hear clients speak about their affinity for a charity, often in terms of, we love this program, or we love this area of the charity, or we love this particular mission of a charity. And they want to restrict the gift for that specific purpose. And so with this in mind, I'd encourage you to contact the charity directly, to have a discussion with the charity about the way in which you want to restrict. Oftentimes, those conversations can lead to very productive discussions about honing in on your purpose and your goal even more to make your gift more effective, and can also help the estate planning attorney when drafting your trust to include specific language that effectuates that goal that you have in mind. I also will mention that from my years serving on boards of different organizations around town and years as a trust officer, I would say that an unrestricted gift is often something that a charity likes to have, because if you think about it, a planned gift may not come to fruition for 10, 20, 30 years. We hope it doesn't come to fruition for a long time. And the charity can use those monies at that future date in a way that is most impactful for them in that given year or years that follow the gift. A lot of times I've been in situations where a charity will came to me as a trustee to say, can we unrestrict this gift? Because the purpose of the gift is frustrated. We no longer have that program, or we no longer are emphasizing that area that the donor wanted to support, all those years ago. And so it's a little bit more work, right, to make sure that the gift gets used in the way that the donor intended. So those are simple bequests. And of course, if you have any questions, please put them in the chat. We'll make sure we can get to them today, or if not, perhaps after. So the next thing I wanted to talk about today is retirement plans, because I feel like so many of us don't have pensions anymore. We have retirement plans, things like IRAs, 401ks, 403bs. And I love this image because I feel like I'm on the left side of the screen, but maybe a lot of you in the audience are already to the right side of the screen where your jar is a little bit bigger, right? And you're wanting to share what's in that jar with others, and you're thinking about how you can do that. And an IRA is a wonderful way to do that. And for today's discussion, I'm just going to focus on IRAs, mostly traditional IRAs, because the rules are very complicated for 401ks, 403bs, and we're just going to limit it to IRAs today. And I wanted to talk about some basic facts that I think we all should be on the same page about before we get into how you can give from your IRA. And the first one is that at age 72, it used to be age 70 and a half, but that's no longer, it's age 72 now. The government requires you to start taking out required minimum distributions, or RMDs, from your IRA. So that's basic fact number one. Second thing I wanted to make sure we all know about is that when you take out a distribution from your IRA, the IRA owner pays ordinary income tax on that distribution, okay? The third fact I want to make sure we understand is that the same is true for the beneficiaries who will inherit your IRA after your death. The distributions that they take out of the IRA are treated as ordinary income to them in the year in which it's distributed to them, or they take out the money. And the fourth fact is one we all know, I think, and why we've socked away so much money in our IRAs is that they accumulate tax-free, right? This is one of the greatest advantages of an IRA and funds like, or plans like it, is that the IRA can ostensibly grow much faster, or at a faster rate than if it were in a taxable account, say like a brokerage or regular old investment account that didn't have that tax deferred status. So the longer the funds stay in the IRA, the better. And that's a really key concept to understand. And then the last thing is that 501c3s, so nonprofits that are 501c3s, are exempt from federal income tax. So with those basic facts, we're going to talk about two ways that we can donate from an IRA to a charity. One is during your life, you can give what's called a qualified charitable distribution. In our industry, it's an acronym QCD, Qualified Charitable Distribution, and it's also known colloquially as a charitable rollover. And what that means is from a traditional IRA, if you're over 70 and a half, so not 72, but 70 and a half, you can gift up to $100,000 to charity of your choice. The funds have to go directly from the plan custodian of your IRA, or your IRA itself, to the charity directly. It can't make a pit stop to you and then go to the charity. It has to go directly from the plan to the charity. And when you make this charitable rollover or qualified charitable distribution, the charitable distribution is not counted as ordinary income to you in that year. So money comes out, goes to the charity, and you don't have to pay any tax on that money. You don't also get to take a deduction for that distribution, for that donation to charity, but it's not treated as ordinary income to you. And so depending on your tax situation, it's a pretty good deal if you don't need to use that money to support yourself. Second way to give from an IRA to a charity is to give all or parts of your IRA at death to the charity. And so while human beneficiaries, your kids, family, loved ones, would be taxed on those distributions at ordinary income tax rates, the charity is not going to pay those same taxes. So 2 ways to give: one, during life through a qualified charitable distribution; second way, at death through your IRA. So you may be asking, well, how do I go about making that distribution at death to the charity? And the way you do it is by through a beneficiary designation form. So I would encourage you to go to your plan provider, plan custodian. So those are the Fidelities, the Schwabs, the Vanguards of the world, and look up, whether you have online access or you have to ask someone, ask them to see your beneficiary designation form. A lot of times, my experience, people set up their beneficiary designation forms when they open the account, and then they never look at them again, right? So that account could be open for 10, 15, 20 years and with the same institution, and it's never touched or looked at or reviewed to make sure it still reflects the person's wishes. So it's really important that you review it periodically and make sure it's in line with what you want. And each plan custodian, and I know this because I worked for an IRA custodian while I was a trust officer, each custodian has their own beneficiary designation form. So there's no standard beneficiary designation form. It would be wonderful if the industry could agree on one, I think, but alas, that's not the case. Everyone has to do it differently. But what they all have in common is that they should allow you to name a primary and a secondary or contingent beneficiary. And I would advise you to look at who you've named in both positions. And if you don't have one, a person or an entity in the second position as a backup, a secondary beneficiary, you know, think about naming one. I think it's a great idea to always have a backup. And most that I see are set up to give percentages. Frankly, I think most IRA and plan custodians want to be able to have the ease of giving a percentage instead of a dollar amount and maybe some percentages. They kind of want to make it easy for themselves, right, to be able to give the funds to your loved ones and your designated beneficiaries. And in order to name the person to fill out the form, you'll need the legal name of the charity and the tax ID most of the time of the charity. So a little work on your part before you fill it out, you'll need to do some digging for some information. And if you're married, your spouse, and your spouse is not going to be the sole primary beneficiary of the IRA, many custodians, I would be surprised if it were not all custodians, will most likely make your spouse sign off on the designation and give their consent to you, for instance, naming AZPM as the sole beneficiary of your IRA, because the reason is because we live in a community property state, and your spouse has, from the custodian's perspective, has a vested interest in making sure that they know where the funds that you've accumulated during your marriage are going. And if you have unique circumstances, some complicated circumstances, for instance, you want to give maybe your IRA to a trust, then a custom beneficiary designation form is possible. In our office, in our law firm, we draft them quite frequently. and clients pay us to make sure that their beneficiary designation form is done properly. But I would say see your attorney if you want to do something special. If you're having a hard time filling it out because you have some unique circumstances, definitely give your attorney a call and check it out. Because I'm talking to NPR listeners and PBS viewers, and I know many of you are binging All Things Considered and Morning Edition and PBS NewsHour and Meet the Press. And I know you all are well-read, well-traveled, you keep up on the news. I didn't want to not mention something that's been in the news, not so recently, but at the end of 2019, beginning of 2020, that affected retirement plans. And it's called the Secure Act. It stands for Setting Every Community Up for Retirement Enhancement. And we'll see how secure and enhanced you feel at the end of my description about this. It went into effect, as I said, in January of 2020, and it really changed the landscape for the way your beneficiaries will receive money from inherited IRAs. So let's talk a little bit about what happened before the Secure Act was enacted with inherited IRAs. So if you were to give, name your loved one, so an individual, a human person, as your beneficiary of your IRA, they were generally, I'm kind of simplifying this, but generally able to stretch the distributions that came out of that IRA for their lifetime, okay? And so this ability allowed us to, from those basic facts that we talked about, defer income tax, ordinary income tax, right, from having to be paid by the recipient of those IRA funds. And so now, after the Secure Act, things have changed. If you're married, you're still in luck. If you leave your tax deferred plan to your spouse, he still has the option, your spouse, still has the option to continue stretching out distributions from the plan for his or her lifetime. So spouses kind of stayed in the same boat. But this is not the case for your adult children. And so a lot of my clients like leaving their IRAs to their, to their children. So for the most part now, if you leave your plan to an adult child, he or she must distribute the assets out within 10 years of your death. So this is a huge change. They went from being able to stretch it over their lifetime to a max of 10 years now. Big difference. Why the change? Really, what I've been reading is it's a revenue raising exercise for Congress, right? The sooner those assets are coming out of the IRA, the sooner we get the government gets to tax them. So that's a good thing in their mind. I also kind of think, this is my own personal opinion, that IRAs were there to kind of replace pensions, right? They were there to serve as an accumulation of your wealth to be used when you retired, right? So the government didn't see these as wealth transfer vehicles, which is what some people with really large IRAs, we have some clients that have millions of dollars in their IRAs, right? We're using them to leave to the next generation. And this is kind of not what they were intended for. So whether you like that or not, that's kind of my view on it. But I will note, Secure Act didn't change your ability to leave plan assets to AZPM or any other charity. So that's kind of a good thing, right? We all like that. I'm kind of running over time, so we'll get through this next piece a little bit quickly. It's gifts via trust. This is a little image that I lifted from Professor Randall James of Texas Tech University. And you can see what a charitable remainder trust is in a very basic sense. Donor makes a transfer to the charitable remainder trust, okay? And charitable remainder trust makes payments for life back to the donor. It could be other beneficiaries. And then at death, anything that's left in the charitable remainder trust goes to charity. So why fund a charitable remainder trust? If you're charitably minded, obviously, it's a great way to make a significant contribution to your favorite charity at your death. It also comes with some income tax benefits, of course. You get an income tax deduction for the present value of the remainder interest in the year the trust is funded. So when you make that initial transfer over to that CRT, you do some fancy math and you get a deduction in the year in which it's made. And then charitable remainder trusts are also exempt from federal income tax. And so what makes them great, it makes them a great vehicle for receiving appreciated property from donors. And so we hear again in the news that Congress is considering, or Biden administration is considering increasing the capital gains rate for top earners. There's also talk about the elimination of the step up in basis of an asset at death. And so these vehicles, charitable remainder trust, may become even more popular if some of those tax changes are enacted. So there's two types of ways that you can receive those payments during life. One is a fixed annuity, so you get a specific dollar amount, same amount year in, year out, no matter what is going on in the trust investment performance-wise. The next way is with a fixed percentage or a unit trust, where you receive a percentage amount of the value of the assets in the trust, and that's revalued annually. So with the unit trust, the amount you get goes up and down depending on the performance year in, year out of the trust. And what can you put in a CRT? It's pretty simple. You can put stock, it can be publicly traded and some closely held stock. You can put real estate, you can put cash, and you can put some types of business interests or hard to value assets. So charitable remainder trusts, great vehicles. So next we're going to talk about a few fun celebrities. I know I pay attention to these stories when they happen in the news because I'm an estate planning attorney and this is what I think about all day. Person on your left, his name is Tony Hsieh. He is an entrepreneur. He was an entrepreneur and a VC, venture capitalist. He's probably best known as the retired CEO of Zappos, the online shoe retailer. And he was also an author. He wrote a book called Delivering Happiness that was really widely kind of viewed as just such a positive message for corporate America. And he died intestate in late 2020 at the age of 46. And I know one of our fundraising professionals at AZPM said, what does the word intestate mean? It means, well, you die without a will, right? So he died without leaving any estate plan. And many stories have been written about him and his death and his estate. He was, like I said, and maybe I didn't say, he was worth $840 million. So big chunk of change there. But a lot of the stories written about him tell about his life of purpose and how charitably and civic minded he was. So imagine all of the charities that missed out because he didn't have an estate plan, especially one that's a taxable estate, right? So huge opportunity lost. Of course, you all know the person to the right, he's Prince, and he died intestate in 2016 at age 57. 5 years later in 2021, they're still administering his estate in Nevada. There's actually a dispute right now between the IRS and his administrator about the value of his estate, but he had a foundation, his own foundation, and he was a really quiet giver, mostly because of his religious faith. So people in the industry didn't really know about all the gifts that he gave to charity and to people. And I know Prince had advisors. I've read a lot of stories about, the fact that they put estate plans in front of him. He just didn't sign them. I'm pretty sure Tony Shea did too. And again, this goes back to the gift that you give yourself, gift you give your family, gift you give to charity when you do an estate plan. It's just so, so important. Last slide, I'm almost done, I swear. A few things that I think I wish people would do before they came to me as an estate planning attorney with regards to their charitable gifts, charitable intent. One is a lot of people are at a loss for what charity to give to. They want to give to charity, but they don't know which charity to give to. There are a lot of reputable charities, especially local charities that are based here in Southern Arizona. And I think our community foundations are great resources for discovering what a good charity, they can help match you up with a charity that suits your needs and kind of meets your values. I would say contact the charity, especially if you want to restrict gifts. Make sure they know what you're trying to accomplish and help you shape that goal to have the most impact. Decide what percentage that you want to give to charity. So a lot of times this is like one of the last pieces I'm waiting for before I can start putting an estate plan together is people say, well, I kind of go 5% or 20%. So think about that before you go and kind of be firm in what you're wanting to do. And then I think be strategic in your giving. I know as working formally in fundraising and being on boards, that is, a sprinkle approach, giving, a little to a lot of different charities is kind of admirable. But I think if you give to fewer charities, you have a greater amount of impact. And thank you for your time, and I'm happy to answer questions after Jim's had an opportunity to go. And sorry, it took a little bit longer.
Thank you, Christina. Thank you for that information. It's a lot to take in, but we got some really good questions. So we will do those right after we hear a little bit from Jim. So Jim Krogmeier, take it away.
Hi, my name is Jim Krogmeier. I'm the Associate Vice President for Gift Planning at the University of Arizona Foundation. First, let me explain what that means. So at the University of Arizona Foundation, we are a philanthropic kind of support mechanism and conduit for gifts to all areas of the university, including Arizona Public Media. So we're here as a central service to support giving, to support donors, and that's what I do. Arizona Public Media is one of the units I do a lot of work with personally. So I've worked with Deb, Enrique, Betsy, I know Hannah, lots of good people over there. So I get to work with them on a regular basis with their donors and their supporters who want to make estate gifts. So I have a couple of items I want to talk about, but some of them are technical. And then I thought, you know what, I might as well hit on some of the kind of softer reasons of why people consider these gifts and what they want to achieve. I get that question from others a lot when I explain to them what it is I do for a living. Top three questions we get from donors. Please explain the relationship between Arizona Public Media and the university and the University of Arizona Foundation. Hopefully I just did that. But we all work together. There are different legal entities involved, different tax ID numbers. That's one good reason to talk to us ahead of time to make sure everything's working smoothly in a coordinated fashion. The foundation does exist to help act as this conduit and to make things a little smoother and a little more flexible. But the main reasons why I want to talk to the charity ahead of time are talking through that designation. What is the purpose that you want to do with your gift? What is the impact you want to see achieved? And to talk through it, make sure, okay, some of it's legal and technical. We'll get you good suggested language to take to your attorney. But then it's also very practical. Like Christina said, these gifts, we might write them today. They might not actually happen until 2 years or 20 years from now. Let's make sure it's a use that is going to work at any time in the future. It's not so narrowly drawn that it's going to be problematic if it comes in at a much later date and all of a sudden that program doesn't exist anymore. I know Enrique, I've worked with a donor, and when the estate came in, it was a very nice gift, but the language was drafted such that it'll take a little thinking to figure out what to do with that. And very good donor intent. I have talked to the attorney who drafted the documents. He thought the donor was in good contact with AZPM, but we didn't really talk through that aspect of it. So that's a good reason to give you peace of mind that your gift will be used as you desire, and it's something that we can carry out. That's not going to create any problems, either practical or legal or other tax issues. A lot of these come down to other, let's help identify issues before they pop up in the future. A lot of these gifts are pretty straightforward, but now and then it's, hey, I was thinking about doing this with my, piece of real estate. Do you think that create any problems? Sometimes yes, sometimes no. Let's just talk it through ahead of time. Christina mentioned beneficiary designations. For a lot of professionals, those are the biggest part of your wealth, is that IRA, that 401k. I know for me, that's going to be probably the biggest part of what I have. That's where I put the vast majority of my savings. Your beneficiary designations are as important or more important than some of your other estate planning documents, and a huge way to be very tax efficient. Christina talked about some of the lifetime giving with your IRAs. She also mentioned CRTs. There are some other types of life income gifts, way more than we have time to get into today, but we can talk about those. There's a lot of tax rules to work within, but a lot of flexibility as well. I'm going to say not to try to be too thrifty when it comes to attorney's fees and fees with advisors. I've seen several examples where people think they're trying to do best to get the most money to the charity by saving on some of those fees, but it can create more fees down the road if there are problems that pop up. So that's some of the technical stuff. Why do people do these gifts? Variety of reasons. What's the motivation for giving? In some cases, it's they don't have any kids and they need to find a place to put their assets, and they know what's important to them. A lot of times, it's just an extension of the giving that they've been doing their entire lifetime. Why not? Why wouldn't we be doing that, right? We give on an annual basis. We give, to this, things are important to us. Of course, or why wouldn't we make a gift in our estate to support the institutions that are important to us right now? It's almost like bringing AZPM into the family, especially when you're doing those fractional gifts or percentages of the whole residue. We really do feel brought in. And I think in some cases, Enrique and his team are probably just as close to our constituents as their own children are, form really good relationships. I also want to emphasize these types of gifts are not just for the Rockefellers. We might see the headlines of the big 7-8 figure estate gifts with huge sums of money, and those are wonderful. But I'd say the bread and butter of what we do are the millionaire next door, or those gifts that are, sizable, sometimes not so sizable 6-figure gifts. It's a way regular annual giving donors can really multiply the impact that they have in a real significant way. Just to give you some perspective, for us and a lot of other institutions with real sophisticated development teams, probably 20 to 25% of our fundraising in any given year is estate gifts. So this current year, it's going to be, I think we're already over $90 million when you add it all up. Some of those are gifts we are working with living donors who are documenting intentions now. Some of those are donors who have passed away, all over the place. And that's university wide. That's not just AZPM.
Thank you. I was going to clarify that, Jim, if you didn't clarify that.
Right.
We wish.
It's everywhere. That's medicine, athletics, fine arts, college, everything. Yeah. All right. So I think I've used most of my allotted time. I am here generally every day of the week, 8 to 5. Give me a call, shoot me an email. Jim Krogmeier at the University of Arizona Foundation.